Hello, everyone, and welcome to another episode of the SIAC International Arbitration webinar series. My name is Chahat Chawla, and I will be your moderator for this webinar. The topic that we intend to cover today is perhaps being discussed at length by companies as businesses globally in the context of the COVID crisis. What started as a health issue has quickly escalated to become an economic issue as well. We are seeing governments across the world issuing quarantine orders, circuit breaker measures, and even complete lockdowns. Many sectors are experiencing reduced demands, disproportionate price increases due to shortage of supplies, and also staff-related health issues. All of these factors have directly or indirectly impacted supply chain operations, manufacturing of goods, M&A deals, and have resulted in other such similar issues. In the backdrop of this situation, companies are constantly evaluating their position commercially and also in relation to their legal obligation. A common question that is being asked is whether the ongoing crisis could potentially be a basis for parties to invoke and rely on force majeure clauses, or whether they are able to rely on doctrine of frustration or material adverse change clauses to excuse performance under their existing contracts. Businesses are also evaluating situations where they may be at the receiving end of such invocations of force majeure notifications. They're also thinking of how to revisit their standard contracts for any future transactions. In this webinar, we take a deep dive into all of these topics and talk about how these issues may play out in the coming months. And we have a star panel to walk you through the legal minefield produced by the COVID crisis. Joining us today is Mr. Chan Leng Sun. Leng Sun is a senior counsel and arbitrator with Essex Court Chambers, Duxton. He's the deputy chairman of SIAC. He's a chartered arbitrator, the immediate past president of the Singapore Institute of Arbitrators, and the former global head of arbitration of an international law firm. He's recognized by top lawyers worldwide by legal directories such as Who's Who Thought Leaders Litigation 2020, Who's Who Legal Arbitration 2020, and Arbitrator Stars 2020. He is described by Chambers Asia Pacific 2017 as one of the best arbitrators and practitioners in arbitration. We also have with us Mr. Alvin Yeo. Alvin is a senior counsel and the chairman and senior partner of WongPartnership LLP. He was appointed senior counsel of the Supreme Court of Singapore in 2000 at the age of 37, the youngest ever to be so appointed. Alvin is, his main areas of practice are litigation and arbitration in banking, corporate, commercial, and infrastructure disputes. Alvin is a member of the court of the SIAC, the ICC Commission, and a fellow of the AIADR, the Singapore Institute of Arbitrators, and the Singapore Institute of Directors, and a former member of the LCIA Court and the IBA Arbitration Committee. He's also on the panel of arbitrators in the HKIC, ICDR, KCAB, CTEC, and the Singapore Institute of Arbitrators panel for sports in Singapore. Finally, we also have with us Mr. Francis Xavier, who is a senior counsel, the regional head disputes practice of Raja and Tan, president of Inter-Pacific Bar Association, and the global president of the Chartered Institute of Arbitrators. So we have an all senior counsel panel for you, ladies and gentlemen, to give you insights on all these tricky issues and complicated questions posed by the COVID crisis. Very quickly, before I invite my panelists to speak, I want to walk you through the format of the webinar. To focus on each of these issues, the panelists would cover each of these three topics, namely force majeure, frustration, and MAC clauses in turn. Questions from the audience are, of course, welcome. We will endeavor to take them either during or towards the end of the webinar. Without further ado, I would like to invite Leng Sun to speak about force majeure in the context of COVID-19. Leng Sun, please.
Thank you very much, Chahat. Good afternoon, everyone. And if you're not from the same time zone, good morning or good evening. I'm going to cover force majeure in the, very brief time that I have before my more distinguished colleagues talk about other interesting things. And what I'll do is actually to approach it from basically three perspectives. One, force majeure as a concept, primarily under common law. And then after that, I will take you through the more important points that you should consider when you're looking at force majeure for the purpose of a contract. And finally, I will sum up by a reminder of some of the main factors to look out for when you're considering a force majeure defense. Now, starting first of all with the idea of force majeure in common law, I should say that the discussions that we have here today would be fairly relevant to most common law jurisdictions, and common law jurisdictions will be obviously the United Kingdom, Singapore, Hong Kong, Malaysia, Australia, and others. So the idea of force majeure in common law countries does not vary very much. And having said that, the question then is, what is this idea of force majeure? The important thing to note, especially for our friends from civil law countries, is that force majeure is not an independent legal doctrine in common law. It is purely a creature of contract. And that means that it doesn't exist independently of contract. If your contract does not provide for it, there is no force majeure defense. And if your contract provides for it, you basically have to look very closely at the terms of the contract to see actually what it provides. There is no presumptions about the defense. There are no presumptions about the consequences. Everything must be stipulated in the contract itself. And this is what I'll get to in the second slide. The other point I want to make is that force majeure is not a term of art in common law. It doesn't have a specific meaning. There's no definition for it. There's no default definition for it. So what you need to do is make sure that in your contract, you actually define or stipulate the events that can be invoked as a defense if you can't perform the contract because of those events. Now, when we are talking about international arbitration and force majeure, most people are aware that in arbitration, the tribunal will apply the law governed by the parties. There is still some misconception among some people that arbitration being less formal means the tribunal does not have to apply the law. And that's not true. An arbitral tribunal must apply the law chosen by the parties to govern the disputes. Most of the time, we're talking about the governing law of the contract. And this means that in common law contracts, the tribunal can only apply force majeure insofar as is provided for in those contracts. An arbitrator cannot decide a dispute based on ex equo et bono, which is based on conscience and equity generally, unless the parties agree that he can do so. And therefore, even in arbitration, we are still talking about force majeure principles according to the applicable law. Now, having said that, this is the common law position, and I would just take a couple of minutes to point out for our common law friends that this is different in civil law countries. I have just two examples here. One would be France, where Article 1218 of the French Civil Code provides that in contractual matters, there is force majeure where an event beyond the control of the debtor, which could not reasonably have been foreseen at the time of conclusion of the contract, prevents performance of its obligation. So there is a definition here of force majeure, and there's provision for the defense and the consequences. Likewise, in China, you have Article 180 of the PRC General Rules on Civil Law, which also defines force majeure. And Article 117 of the PRC Contract Law, likewise, have similar provisions. So in these countries, force majeure is a statutory defense, which is why there's often a lot of misunderstanding and confusion when you're dealing with parties from different jurisdictions, and especially in these times when people are all talking about force majeure, but actually having very different concepts and consequences behind them. China has also, quite early on in January, when it was in the darkest days of the Wuhan lockdown, had issued a notice certifying a force majeure event, more particularly by the China Council for Promotion of International Trade, CCPIT. How this certificate is useful, whether it's useful, depends on the governing law of the contract. Obviously, it would be useful for countries that recognize that certificate. The LNG importer, ENOOC, for example, had declared force majeure and relied on that. But that has not been accepted by the oil major Total. So there is still an evolving situation when it comes to disputes. So that's the difference between common law and civil law. What I want to do next is to talk about force majeure in common law, and in particular, the force majeure provision in contract. What should you look out for? What are the important terms? So if we move to the next slide, obviously the first thing you want to provide for would be, what are these events? I've already said that force majeure is not a term of art. Therefore, you will find many contractual provisions actually spelling out what are the events that will give rise to a recognized impediment, which can relieve a party of performance. But you notice that there are also usually some general provisions like act of God or circumstances beyond a party's control. I will just illustrate some of these terms, more common terms. Epidemic is not normally found, but if you don't have that, then you have to rely on the casual provision. One example of a very simple clause can be found in the Singapore Court of Appeal case of RDC Concrete. I have here the citation for this case for those who are interested. The clause in RDC Concrete is actually very simple, and it says in the event of any circumstance constituting force majeure, which is defined as an act of God or due to any cause beyond the supply's control, then the obligations shall be suspended. Okay. Now, one thing you'll notice here is that in RDC Concrete, they actually define force majeure as an act of God or any cause beyond the supply's control. Then the question you may ask is, what is an act of God? Surprisingly enough, although it's very common in contractual clauses, there are not many cases that actually dwell into the meaning of act of God. It's generally recognized as natural causes or natural disasters such as flood, storm, or earthquake. But probably not many cases actually had to struggle too much with the meaning, because in many cases of force majeure provisions, you will find a casual provision, and that is circumstances beyond the control of a party. And therefore, most of these cases turn on the facts as to whether the circumstances were beyond the control of that party that seeks to rely on it. Now, would act of God cover a pandemic or epidemic? I suppose you can argue that, especially when it's of such a severe level, where it actually disrupts global transportation and logistics worldwide. And if you want to argue about meaning, I suppose you can say the act of God can cover a plague, just like in biblical times, it is considered an act of God. So we don't need to dwell too much on that meaning, because the important thing here is most clauses will provide for the casual provision, circumstances beyond the party's control. If you look at the next item in the clause, it's very important to provide a link between the event and the non-performance. Most clauses will put it very simply, something that prevents the performance of the contract or the failure to perform was caused by an event. I'm going to use here the ICC force majeure and hardship clause of 2003 just to run through some of these common provisions that you should consider. The ICC clause is a more comprehensive one. I'm not saying it suits all parties, but it's more comprehensive than the one that you see in RDC concrete. So having defined the event that can amount to force majeure, you want to deal with the link and the question of causation. The ICC clause is simple in that regard. It says failure to perform was caused by any of these events. But in some contracts, you will find other words being used. And therefore, we need to emphasize time and again that how the force majeure clause operates depends on the wording of your contract. So in some contracts, you have words like performance is prevented by a force majeure event. What does prevent mean? That can be a pretty high threshold because courts have held that it's akin to impossibility of performance and not just inconvenient. Whereas if you use a word like disrupt, and this was a term that was used in the other case I have in my slide, that's the Holcim case, Holcim against precise development, which is in the next slide. In that case, you have a clause that says if the supplier or the supply is disrupted by virtue of inclement weather, strikes, and so on. The Court of Appeal in that case considered the meaning of disrupted and decided that it was of a lesser degree of severity than prevent. So it would suffice if performance is commercially impractical, as opposed to impossible. So if performance of the contract is commercially impractical, then it may amount to a disruption. And here, while we are talking about the causation part, I have to stress that your force majeure clauses do not give you an easy way out in most cases. Even a word like disruption or commercially impractical doesn't mean that just because it has become more expensive to perform or the cost has arisen, you can claim that it's no longer possible to perform or that your performance has been disrupted. For example, the Court of Appeal in Holcim had considered what if the cost of your supply goes up, the price of goods goes up. And that in itself is not sufficient to satisfy the causation between the event and non-performance. However, it's a matter of degree. And for example, the court left open the question of what if performance or the price has become astronomical? Could it amount to disruption or prevention of performance? That is an open question. Okay? But a simple price increase will not suffice. I go on now to other possibilities, okay? Which is what if we face a situation such as a general global disruption, the way that we are seeing now. Surprisingly, we have not had cases that I know of dealing with pandemics. But if you take one example of a case, China Resources against Magenta, which is in the next slide as well, you'll find that in that case, the disruption was caused by the breakdown or disintegration of USSR in the 1990s. And the shipment that was supposed to be done was supposed to be a shipment from the USSR. The court accepted that in that case, the general disintegration of the USSR, disruption to communications and transportation were enough to amount to a situation akin to a war. The force majeure clause there had an exception for war. And therefore the court felt that it satisfied the requirements of force majeure. So if you have general disruptions on a global scale to transportation that actually make it almost impossible for you to perform, you can actually look at your clause and see if you can invoke it. Now, there are many other provisions that you should look at. I'm not going to go through all of them one by one. Most clauses would have a notice requirement, so pay attention to that. And then the consequence could be just a temporary relief, or if the duration of the impediment lasts, the contract might provide that you can terminate the contract. The ICC clause provides for that as well. One very important factor is the party that wants to invoke force majeure is usually required by the contract to take reasonable steps for mitigation or to avoid the impediment. I wouldn't say that is a presumption that you must do so, but most contracts would require you to do so. So take a close look at the contract. So I will just sum up here and jump to my last slide, which is basically if you are facing a situation of force majeure, look at the events, okay? Identify the event, and there are more than one you want to rely on. Give notice, because notice is very important and is a usual requirement. Consider whether you are talking about temporary relief or where performance has become impossible, not just suspended. You have to get your contractual clause to see what rights you have. And above all, you have to act reasonably. Don't just sit down, do nothing, and not mitigate the situation. And I do have one last point, of course, that is, you don't often just consider one option in isolation. Along with force majeure, which is a contractual, you have a non-contractual concept such as frustration, which will be covered by my friend Francis Xavier. But I leave you with a comment from RDC Concrete about frustration. And the Court of Appeal says the prevalent practice of incorporating force majeure clauses into commercial contracts stems largely from the blunt nature of the doctrine of frustration, because it has been said that the juridical basis for the doctrine of frustration is unclear, the doctrine is difficult to invoke, and the consequences are drastic. So I couldn't resist citing that case and leave Francis Xavier with that happy thought. Thank you.
Thank you, Leng Sun, for that very succinct summary on force majeure clauses. I think we have time to take one question at this time. We have a question all the way from Spain. Luis Maria asks whether lack of demand of a certain product due to COVID-19 crisis can be a cause to resort to force majeure by importers of such product under English law.
Well, he's asking about English law, but I think it's probably the same under Singapore law. And I do actually recall an English case. The short answer is no. There was a case during the economic crisis of 2008, 2009, a case called Tendering Aviation Holdings against Aero toy store. And in that case, it was the buyer was supposed to take delivery of a jet plane, a Bombardier aircraft. But due to the crisis, the buyer didn't do so and tried to invoke a force majeure clause. The English court held that you can't say that an unanticipated, unforeseeable spiral of the world's financial markets is a force majeure event. So generally, the courts do not accept general economic conditions as a force majeure event. You can also watch, for example, the ongoing dispute between what I mentioned just now, CNOOC and Total, where CNOOC tries to use the Chinese certificate, right, to say that it's a force majeure event to get out of the LNG import contracts. But that's been resisted by Total. But as to whether they'll succeed or not, I'm in no position to comment, because you actually have to look at the facts of that case. But I wouldn't say that just because supply is down, you can get out of your contracts, even with a force majeure clause.
All right. Thank you very much, Leng Sun, for your remarks. I'm certain that there are plenty of key takeaways for our audience there. One of your recommendations was for companies to perhaps look at alternative grounds such as doctrine of frustration This is actually a very good place for us to segue into the second subtopic on the doctrine of frustration. There are plenty of queries in relation to the doctrine of frustration and how one can rely on the same in support of their argument. I would request Francis at this point to elaborate on the concept of frustration, the legal standards to prove frustration, and how does one view this doctrine in these times?
Well, thanks, Chahat. Now, basically, frustration, before you get to frustration, you have a contract, right? And the contract is entered into by parties with certain level of knowledge, expectation, assumptions. And following upon the entry into of the contract, what the doctrine requires is that there are events that occur that so radically impact on the contract, the carrying out of the contract, that the performance of the contract is rendered, what the law says, the test is radically different, right? So something has happened which is unforeseeable, which was not foreseen by the parties, and the thing was not caused by the fault of one of the parties. And even though the law uses the test radically different, what the law is really talking about is supervening impossibility. So in the way the parties contemplated that the contract will be performed, because of this new event, which was unforeseen, it is now not possible to carry out or run the contract in which the parties, with the knowledge that they had at the time they entered into the contract, presumed or expected the contract to be run, right? So taking the case, I think, Chahat, one of the cases that you mentioned made reference to is this Alliance Concrete case, where that was caused by the sand ban, right? And there was a sand ban. There was a contract where Alliance Concrete was to supply ready-mix concrete to Sato Kogyo, a contractor. And what had happened was, because of the contemplation of the parties at that time was that Alliance Concrete will get sand from Indonesia, and then based on that sand, make available ready-mix concrete to Sato Kogyo. And so when the Indonesian sand ban took place, the court clearly was confronted with an event which the court ultimately held was a frustrating event, because Alliance Concrete could no longer procure sand from Indonesia in order to supply RMC, right? So the fundamental expectation of the parties were rendered impossible, right? And so once it's a high bar, as Leng Sun has said, once you satisfy that high bar, the effect is that the contract is terminated from the date of the frustrating event, right? Now, but the contract is not rendered void ab initio. So as at the date of the frustrating event and moving into the future, the contract is dead, but antecedent liabilities will have to be performed. Debts which were owing by way of the contract prior to the frustrating event will have to be honored. Now, Leng Sun mentioned this quote, and that the frustration is seen as a blunt tool. To a large extent it was, and perhaps some people will still see it as a blunt tool. The situation in common law used to be that once the contract is ended, losses lie, from then on, losses lie where they fall. Now, in order to mitigate the rigor of that strict rule, we have in Singapore the Frustrated Contracts Act, which seeks to regulate the parties' conduct in terms of liabilities and obligations, in terms of benefits that should have been accrued after, including benefits that had been accrued before. The Frustrated Contracts Act seeks to distribute, the benefits that have been obtained by one party or the other in a fair and reasonable manner. Now, England has a similar act, Hong Kong has a similar act. So just bear in mind that in terms of the effect of the frustrating event, if you succeed in showing that the doctrine applies, there is such a thing as the Frustrated Contracts Act. And I think that should take care of your questions for now, Chahat.
Yeah, thanks, Francis. I think you mentioned that one of the tests that perhaps the courts or the tribunals would look at is that the supervening event is unforeseen. Hypothetically, if one of the parties, hypothetically, if parties enter into a contract at this stage, knowing very well that there's an ongoing COVID crisis, do you think that they would be able to invoke the doctrine of frustration?
Now, that's a very good question. And, but just remember that the fulcrum is supervening impossibility, right? So you can have a situation when a contract is entered into before the COVID crisis in November last year, and one could still say a viral pandemic is not unforeseeable. It should have been foreseen. We've had SARS, we've had the MERS COVID incident, coronaviruses has been with us since time immemorial, as far as we remember. But that's not the key. The key is, has the supervening impossibility. So first of all, you need to establish impossibility. Not that the contract, as Leng Sun described, not that the contract has now become expensive, although the courts do say that if it's become astronomical, they may allow the doctrine. But in terms of the fact that the contract is harder to perform, the contract is more expensive to perform, if it is still possible to perform it with those difficulties, because the supply chains are not disrupted, even though you and I can't leave our homes, but supermarkets are being supplied, and so you still can perform the contract, then obviously it will not be frustrated. But if you can show that there is a supervening impossibility caused by the lockdown, because you're now regarded as a non-essential service and you are locked down, and even though a viral pandemic could have been foreseen, perhaps the contract was entered into in January and the COVID-19 was already raging through Wuhan and spreading to the rest of the world, but parties could not anticipate at that time that Singapore would go into a full lockdown, for instance, then the sense is that you can still rely on the doctrine.
All right. Thank you. Thank you, Francis. I think at this point, we'll take one question from the audience. The question is, how important do you think contemporaneous documents are to prove or disprove a case, specifically with regard to disputes which may arise in relation to the COVID crisis, or in case a person has to prove the doctrine of frustration? So how important is that from a tribunal's perspective?
Now, when you're talking about the COVID crisis, for instance, maybe you don't need much documentation because everyone and his pet canary seems to know every aspect about the crisis, right? But if you're talking about a localized event, your ships can't pass through the Gulf because the Somalian pirates are out in force, and perhaps the sand ban, the effect of the sand ban on RMC suppliers was not so widely known all across, even in Singapore. So it's very critical that you document in correspondence the difficulties. If you're the party who is unable to comply or fulfill your contractual obligations, it's very important that you document your difficulties, in particular, the steps that you're taking to overcome these difficulties and failing, right? You need to document it because that is the way you persuade the court that you simply could not perform. I mean, take the Alliance Concrete case, for instance. One of the arguments that was run was, even though sand was not available from Indonesia, you're getting sand from Malaysia, you're getting sand from Vietnam. There were people hoarding sand in various parts of Singapore, and even though they were selling it at, high prices, black market prices, but you still can get it. But the key there was that the contemplation of the parties was that the sand for this contract will come from Indonesia. And so, fortunately, the party in that case had taken great pains to chronicle how they simply could try every available avenue in Indonesia and they couldn't get it. Now, if you don't have that kind of evidence, it may be difficult for you to show that you had gone the extra mile to fulfill your obligation, because that bar is high. Chahat.
Yeah. Thank you so much, Francis. I have one final question to ask you before we move on to the MAC clauses. I think some viewers may not know that the Sandband, the Alliance Concrete case is actually argued by you before the Singapore Court of Appeal. I understand that in this case, the position that the appellant took was that there was in the alternative force majeure clauses as well prevalent in the appropriate 2 out of 3 contracts, if I'm not mistaken. So in terms of formulating strategy, how did you approach this question? How did you pick the doctrine of frustration ahead of force majeure while, putting forward your point in your case?
Well, the difficulties in that case was that as Leng Sun, I think, has helpfully outlined, being able to come within a force majeure clause did not mean that you were off the hook. It may mean that your obligations are just suspended for a while. You get an extension of time effectively. But in that case, it was crucial for Alliance Concrete that they established that there was something more fundamental. It was not that their obligations were simply postponed, which would have still created practical difficulties in the fact that the other side was arguing that Alliance Concrete had effectively repudiated the contract. And because frustration is harder to prove, we decided to try and satisfy that bar first. Because if you satisfy the bar, then you're home. And if you can't, then in the alternative to argue perhaps force majeure with the attendant less favorable result of obtaining an extension of time and saying that you were still within the time not to perform the contract. But there were ground difficulties from a pragmatic point. So the judgment call was to go for for frustration as the principal argument.
All right, thank you so much, Francis, for your remarks and those insights on the doctrine of frustration. I'm sure this was very helpful for our viewers. We will now move on to the last part of the webinar on material adverse change or MAC clauses. I would now like to invite Alvin to talk about MAC clauses and share his insights on the same.
Thanks, Chahat. Good afternoon, everyone, or good morning if you're in a different time zone. I have the difficult task of following on not just after 2 distinguished speakers, but also dealing with what is probably the least familiar to all of you of these 3 concepts that we're talking about today. So to try and help us navigate through this topic, I prepared some detailed slides, which hopefully will help you to sort of clarify or help me to clarify the situation with you. Not just because I'm not as telegenic or Zoomgenic as Francis, who kind of filled the whole screen with his vigor. So jokes aside, let me go into the first slide. Now, material adverse change clauses are creatures of contract. They're sometimes also known as material adverse effect. So some of the cases will refer to them as MAE clauses. So it's not a common law or civil law doctrine. Unless this is in a contract, they don't arise at all. And what they're designed to do is to allow a party a particular remedy, generally termination of the contract, upon the fulfillment of a set of circumstances, often not defined, but which comes under this sort of concept or rubric of material adverse change. Now, as you can imagine, and this is the 3rd bullet point on the slide, because they're matters of contract and because they're broadly defined, because ex hypothesi, you haven't anticipated the particular situation that has resulted in a change. There's room for disagreement, which is fertile ground for arbitration and litigation. Over to the next slide, please. I said that we're less familiar generally, but material adverse change clauses are widely used in particular sets of contractual transactions. And I've just given you an example of 2. So large banking or financing transactions, where essentially there is a gap in time between the signing of the agreement and the closing. Because that's really what you're trying to sort of guard against, some change that takes place in the interim or perhaps over the duration of the loan. And essentially what the lender is trying to do is protect itself against some change that affects the solvency or financial stability of the borrower. The other class of contracts where typically these clauses are employed are M&A transactions. Again, there's a gap in time between the signing of the contract and the closing. And again, what the acquiring party, buyer, is trying to do is to make sure that there isn't some change in the interim which makes the value or affects the value of what the company that it is buying. If I can go to the next slide, some of the sort of events or categories of events that MAC clauses have tried to cover would include events which relate to the target itself and concern changes in business of the target. Later on, when I come to discuss MAC clauses in comparison or in contrast with frustration or force majeure, you'll pick up on some of these differences. But one key difference is that MAC clauses typically focus on the effect on the company or that's the subject matter itself, and not just some general event which may affect everyone in the same class. They can cover, however, macroeconomic developments. So you heard Leng Sun talk about whether economic situations could constitute force majeure. Well, in a MAC clause, it is possible to define, say, some movement in the market which affects the share price dramatically. It is, because of freedom of contract, you are able to sort of put this in your contract as something that constitutes a material adverse change. The third class of events are perhaps something that you would be familiar with after hearing about frustration and force majeure. Those would be non-business related incidents, war, natural disasters, and I suppose pandemics. Over to the next slide, please. Now, unfortunately, unlike Leng Sun and Francis, can't pull up a Singapore case for you because there appears to be a dearth of Singapore authorities on MAC litigation. But there are foreign precedents which are instructive. So while obviously each case turns on its own facts and the circumstances and the drafting of the clause, there's some general sort of principles that one can elicit from the cases. You do need to have some significant change in the company's business performance or its sort of value. So something peripheral, in passing, partial, would probably not pass muster. The duration of the change should not be temporary. That's an important difference because unlike, say, a force majeure clause, which could have a certain suspensory effect during a period of which, when it applies, a party's obligations are suspended. The general sort of objective of a MAC clause is to actually allow one party to exercise a particular remedy, usually termination. And hence they look at a change that is something that is not transient or passing, but has a certain significant duration, although it obviously need not be permanent. Third bullet point, company versus industry effects. You're not talking generally about something that affects the whole class of companies equally, but something that affects the subject company in particular. It obviously should not be a contemplated or sort of seasonal and risk in the sense that something that happens every now and then. And of course, the change has to be assessed from an objective standpoint. The next slide, please. I thought I would just sort of pick up two cases to try and illustrate these points, one from the UK and one from the US. So the first case study I pulled up for you is a case called Gruppo. There's a Spanish property developer, Gruppo Hotelero Uvasco, had financial difficulties in 2007 and entered into a loan agreement with essentially a fund, Carry Value Added SM. There was an MAC clause which provided that in event of default would occur if any representation made by G was untrue in a material respect. And one representation that G had made was that there'd been no MAC since the date of the agreement. And what the lender, Carey, did was they actually suspended advancement of loans partway through in June 2008, claiming an MAC had occurred, which had resulted in substantial deterioration in G and its parent company's financial condition and prospects. Next slide, please. So Carey claimed it validly terminated the contract pursuant to the MAC clause and sought to support that by pointing out that Gruppo had suffered a loss of 126 million euros in 2008, which was many times, something like more than 10 times the loss it suffered the year before. It has also stopped paying its bank debts. And of course, there was a severe Spanish property market downturn, which affected G and its parent company. Gruppo, on its part, counterclaimed that G was in breach by failing to advance the loans, and also arguing that external economic changes should not be considered. Next slide, please. The High Court of England and Wales found that an MAC had occurred, holding that you could consider compelling evidence of external economic and market changes. They also held that the MAC must significantly affect the borrower's ability, in this case, to perform its obligations, which would be to repay the loan. The change cannot be temporary. It had to be something that had a certain sort of like duration, not transient. And the fourth point, because you'll remember that Gruppo was already in financial difficulty in 2007. You could still have an MAC where you had a worsening of conditions beyond what you knew at the time you entered the contract. Next slide, thanks. Another case study I wanted to pull out to show you was, this is the Delaware case, Acorn versus Fresenius. This was an M&A transaction. And Fresenius had inserted in the condition that no MAE, material adverse effect, had disproportionately affected Acorn, the target, had occurred since the date of the agreement. In March 2018, Fresenius terminated the agreement on the grounds of an MAE and sought to rely on that by showing that A's valuation had declined from the year before by 86%, and its share price had fallen almost 2/3, from $32 to $12.50, with no sign of abating. And this was in contrast, not just in 2017, but the 5 years preceding, where A had consistently shown growth. And there were whistleblower letters that A had not complied with FDA regulations. Next slide, please. The Delaware Chancery Court found an MAE, and its reasoning included that you had to weigh sort of industry versus company-specific risks. So in a sense, Fresenius, the buyer, had assumed systemic risks, meaning they could wriggle out of the deal if there was systemic risks. But A was responsible for company-specific risks, and there had been a greater underperformance relative to its peers, and hence and was disproportionately affected by new entrants. So this is something more than affects that whole group of companies in the class. The duration requirement was also satisfied because this was an effect or a sort of situation that would affect them over a period of years, not months. And this drastic underperformance was not envisaged when the agreement was signed. Next slide, please. I now just wanted to compare and contrast MAC with force majeure and frustration, since I come up last in this sort of series of speakers. So like force majeure in the common law sense, MAC clauses and force majeure require contract terms. Frustration occurs automatically as a common law doctrine and under the Act, as you've heard, Frustrated Contracts Act, as you've heard from Francis. Foreseeability. Frustration requires something unforeseen. if you've foreseen it, it becomes much more difficult to plead frustration. Force majeure and MAC do involve some degree of foreseeability in the sense that the parties have sort of drafted a clause to try and cover that eventuality. But the sort of classes of events are sort of very broadly defined. And in a sense, it's the actual change is something that the parties couldn't quite, or was beyond what parties would anticipate. Next slide, please. Both of them, all three of them require significant change. And then in terms of duration, unlike force majeure, which can have a suspensory effect and perhaps frustration, because there are two schools of thought about whether frustration can be suspensory or is extinctive. MAC has to be sustained over a long duration and be considered likely to persist. Mitigation, force majeure and frustration do require a party to take mitigating steps. But if you can invoke MAC clause because your situation falls in that category, you don't need to do anything else beyond invoking it. Next slide, please. Impossibility of performance. Force majeure and frustration require impossibility or radical change in the nature of performance. Now, MAC does require your performance to have been significantly affected, but again, once you fall within that event, that class, which can constitute a material adverse change, then you don't need to go further and show that it's impossible to perform. Triggering events. Force majeure and frustration involve external events, and MAC can also be triggered by an external event. But there's a lot of focus, or the primary focus is on the specific effect on the target company. Next slide, please. I wanted to briefly touch on the temporary measures, the COVID-19 Temporary Measures Act. It's something quite different from the three concepts we're talking about, but it's probably something on everyone's mind, certainly those of you who have a base in Singapore. So what this act provides for is a temporary suspension of obligations to perform certain classes of contract. It does need to be affected by COVID-19, and if there's a dispute on that, there's a sort of assessment process that's been created to try and resolve these quickly and cheaply. There is a certain deferment of proceedings, but that covers court and domestic arbitral proceedings, and international arbitration proceedings can carry on during this period. And there's a kind of like, sort of like tolling effect for limitation periods, which are extended while the period of this sort of prescribed period under the Act. Next slide, please. What I've set out here are just the classes of contracts that are affected by COVID-19. Not generally the subject of international arbitral disputes, but I suppose theoretically you could. The first one on security are relating to lending. The second one related essentially to commercial leases. Performance bonds and liquidated damages are for construction contracts, but you would typically see, the call of the performance bond tends to be the subject of court proceedings if one side seeks to injunct the call on the bond. So if I could go to the next and last slide, Mike. I just wanted to say COVID-19 measures obviously something that's very important for certain classes of contract in Singapore, but they are different from an MAC clause because they're created by statute, not contract. They are suspensory in nature. These obligations to pay your loan, to pay, pay liquidated damages if you're in delay, to pay rental, are deferred or suspended. They don't go away. And that's different from MAC clause, which, as I said, if it's triggered, usually gives one side the right to terminate the contract. Now, the third bullet point is really my opinion. The issue has obviously not arisen for determination, but I would argue that it would be difficult to rely on the suspension of contractual obligations during the prescribed period as a triggering event under the MAC clause. It may well be the subject of a case. You can think of arguments going either way. But as I said, that might be an interesting one that comes to our courts. And of course, the last one, after the prescribed period, then parties can go back to relying on their contractual rights, including on MAC clauses. And on that note, I sort of end my little presentation. Thank you.
Thank you so much, Alvin. I think this brings us to the end of the webinar. I think today we had more than 1,000 viewers with us throughout the session. It remains for me to thank the panelists and our viewers for their time. Before we end, I would like to remind everyone to fill their feedback forms, which should appear on your screens. And also, I'd like to inform you that this is an ongoing SIAC International Arbitration Series, and our next webinar is scheduled for tomorrow at the same time. Tomorrow's session in particular would be very interesting because it's a conversation between our President Gary Bond and SIAC's Deputy Registrar and Center Director Kevin Nash on life law and arbitration during a pandemic. The invitation links to the webinar can be found on our website, and we hope to see you all tomorrow. Thank you once again for joining us, and please stay safe.